really advocate for a client, but here's the thing. He put himself in a box when he said, my client's damaged.
You get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Hello, my name is David Bruno. I'm a partner at the Bianchi Law Group. We are a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. Our office is in Parsippany, New Jersey, and we handle criminal defense, domestic violence, municipal court, and appeals. Today, I'm going to be talking about harassment, which is codified in 2C33-4. If you like what you're hearing, subscribe to our channel. We have several links in the description on YouTube for an ebook for criminal procedure. You can book a consultation, and you can call us at the office 24/7. I'm here with my law partner, Bob Bianchi. Hello, Bob.
How you doing, Dave?
Bob's the former head Morris County prosecutor, as well as Danielle Esposito, assistant prosecutor, former assistant prosecutor. Hello, Danielle.
Hi, Dave.
Also with me is Kayla Rowe of counsel to the Bianchi Law Group, a former assistant prosecutor, and someone who's argued 6 times before the New Jersey Supreme Court, countless times before the appellate division. Welcome, Kayla.
Hi, Dave.
And again, team of former prosecutors here, and we're talking about harassment. And harassment, like I said, 2C33-4. And harassment can be a petty disorderly persons offense that is prosecuted in the municipal court by a municipal prosecutor. Or it could also be the predicate act for a restraining order in the family part. And it's definitely our most common predicate act that we see in our domestic violence practice, that it's used to get the temporary restraining order and could ultimately be a final restraining order just on the harassment itself. So harassment is frequently discussed in legal opinions because it could be overbroad in its application. I mean, it could even cross over into constitutional speech that's protected by the First Amendment. So we see cases decided that really provide clarity for us as practitioners in these types of cases. And the most important thing to prove a harassment from a plaintiff's perspective is the first element, which is a purpose to harass. Okay, so that must be the intention, the conscious object of the defendant or the defendant in the restraining order action to harass someone. In the domestic violence context, we frequently see that defendants are acting with different types of purposes. Like if there's a child in common and there's an argument over the child or medical treatment or schooling or things like that. I mean, oftentimes we get these restraining order actions involving harassment where there are very contentious divorce actions that have back and forths and arguments and things like that. And oftentimes plaintiffs try to use the harassment statute either to prosecute somebody, to get charges filed for harassment against a defendant in the municipal court, or to get the restraining order. And the harassment statute has 3 separate subsections, A, B, and C. Now, the A subsection is really geared towards communications. And that requires that someone makes or causes to be made a communication or communications anonymously or at extremely inconvenient hours or in offensively coarse language or any other manner likely to cause annoyance or alarm. Now, read on its face, that could be a very broad application. But like I said, the state Supreme Court has really reined in A to not cross over into protected speech. So there's a case, State versus Hoffman, that really interpreted that and required that the language be invasive of expectation of privacy. B, on the other hand, subjects another to striking, kicking, shoving, or offensive touching, or threatens to do so. Going to be a little similar to the assault statute, and I'll ask Bob to discuss that a little bit further. But again, for all of these subsections, A, B, and C, they all require that purpose to harass, and then whether or not A, B, or C is applicable. And then finally, C, which is engages in any other course of alarming conduct or of repetitively committed acts with the purpose to alarm or seriously annoy such other person. That has been interpreted to rein that in as well. State versus Burker, a New Jersey Supreme Court case. And again, these are all important to know. We're not going to discuss them thoroughly today, but just know purpose to harass, 3 separate subsections, to either be prosecuted in the municipal court for harassment or to be used as a predicate act in the domestic violence context. Bob, former head county prosecutor, talk to us a little bit about subsection B and how close that is to the assault statute.
Well, like Dave, you said before, and it's really the most important thing, and a lot of lawyers who practice in this area don't get it. One is for the purpose to harass, as opposed to the assault statute, which is the purpose to either create bodily injury or serious bodily injury. So the purpose is the same mental state, like Dave said before, the conscious object to do a thing. And the reason why this is important, of course, it's different than assault. But like Dave said before, when you look at the section that says likely to cause annoyance or alarm, well, this doesn't mean every conduct. Not everything somebody says to you is going to implicate that law. And like Dave said, it can also be a disorderly persons offense, or it could be what they call a predicate act in a temporary restraining order scenario. What does that mean? There are a number of categories of crimes and offenses that you have to first be responsible or alleged to be guilty of before you can get a final restraining order. And then you have to show in that restraining order that there's a need for your continued protection. So harassment becomes this huge ground upon which people, because you see how loose the language is, upon which people file for temporary and ultimately seek final restraining orders. So it's an area where a skilled practitioner, Dave, needs to be very understanding of what the case law is, because as you suggest, look, the courts get that when people are going through difficult times, they may say bad things to each other, they may act mean towards a person. That is not going to necessarily be a violation. A person could be angry and saying something because their relationship is on the rocks, but it's not their purpose to harass that person, even though that person may feel harassed. I think you get what I'm saying, Dave, right? Because this is an area where people come to us all the time and they're telling us the conduct and they're like, I felt harassed. But we have difficulty in showing that that was what the person's intention was. That's what his purpose was, Dave.
Yeah, sure. I mean, we see it all the time in the domestic violence context. And believe it or not, just this harassment alone, this allegation could be used to remove a defendant out of the marital home and even stop parenting time. And we often see it. But there's a difference between marital contretemps, and it's words that are used frequently in our courts. Marital contretemps is the basic arguing that goes on in either a marriage or a divorce that's not harassment. Danielle, if you could just talk to us a little bit about the sentences that are possible for harassment.
Thanks, Dave. So yeah, under the harassment statute, this is a petty disorderly persons offense. So in New Jersey, that is the lowest charge or degree of a crime that you can be charged with. So for a petty disorderly persons offense, you are facing up to 30 days in jail on a harassment charge. There is a part of the statute that does increase the violation for the harassment statute to a 4th degree, and that is if the individual, if the defendant charged with that crime of harassment is on parole or probation at the time of the offense, that can actually increase the degree of the crime from a PDP, a petty disorderly persons offense, to a 4th degree crime, which carries with it up to 18 months incarceration.
Thank you, Danielle. I'll turn to Kayla Rowe, our appellate extraordinaire, argued before the Supreme Court 6 times. And like I said, these types of cases, these harassment convictions and the final restraining orders involving harassment, they frequently go up on appeal to the appellate division and the New Jersey Supreme Court. As an appellate practitioner, what do you look for when you evaluate whether or not there is an appeal on a conviction or a final restraining order involving harassment?
So Dave, when you're looking at an FRO that's already been in place, already been issued, you're looking to make sure that each of the elements has been satisfied by the opposing counsel, and also that the judge clearly articulated facts underlying each element. So like we were talking about earlier, it's difficult to prove the purpose to harass. This is where judges sometimes in the trial court get a little tripped up. They don't make clear findings, they don't make specific findings. And if there are no factual findings in the opinion that they often give on the record, so they're talking like how you and I are talking now, they're not necessarily reading from a script, and it's certainly not a written opinion that you might see from the New Jersey Supreme Court. But if they don't have those specific factual findings bolstering that there was a purpose to harass, that's an opportunity for us to come in, file an appeal on your behalf, and get the FRO vacated. So Dave, that's exactly what I'm looking for, making sure that everything is bolstered.
Thank you. If you like the video, give it a like, subscribe to our channel, the Bianchi Law Group YouTube channel. We are frequently putting out videos like this on substantive crimes, legal issues, developing legal issues, both in New Jersey and nationally. Bob Bianchi and I are both national legal analysts, and we appear regularly in the national media. We are a team of former prosecutors that aggressively fight the government when our clients are charged with crimes. We handle criminal defense, domestic violence, municipal court, and appeals. You could find us on our website, bianchilawgroup.com. You could find us on Twitter, Facebook, Instagram, Google+, LinkedIn, basically everywhere. We hope you found this content and the content in the description valuable, and we thank you for watching.